title of this blog is "What Considerations Do I Have in Filing a Lawsuit for a Personal Injury Accident in Massachusetts?" The first consideration that you should take into account is the statute of limitations. I say this because over the years I've been surprised at the number of calls I get from people who, on the eve of the 3-year statute of limitations, are thinking about filing a lawsuit. I suggest to you to have the best approach taken on your behalf. Don't wait that long, because witnesses disappear, facts are harder to deduce, and things of that nature. So what you want to do is, when you feel that you've been wronged civilly, you want to speak to an attorney pretty much as soon as possible. And in no event do you want to run afoul of the statute of limitations. Now, in Massachusetts, it's generally 3 years, but there are exceptions and differences, such as for minors, such as a claim against a municipality or a political subdivision thereof pursuant to Chapter 258, carries with it a 2-year notice, and although the statute of limitations is 3 years, and a claim against a city or town under Chapter 84 carries with it a 30-day notice, and that's for a defect in the way. So 3 years is only a guideline in the typical personal injury case. It is by no means the exact statute of limitations in every case. In fact, it is not. After that, you want to consider the county in which you live. Now, the venue statute, that is where you can bring suit, in which court, say in the state court system, the venue is the county where the accident occurred, or where the plaintiff lives, or the defendant lives. And a corporation is also deemed like a person, so the corporation would have a place of residence. And it would be up to your attorney to find the most favorable venue for you. There is jurisdiction and there is venue. I am talking right now about venue in the state court system. And of course, anytime there is an injury or physical injury, there are medical reports to be gathered, medical opinions to be had, and things of that nature. The client directs the treatment, not the attorney. An attorney can sometimes hire an expert for evaluative purposes, that is, purposes of evaluation, but the attorney is not to be central in the treatment, or not to be involved, really. The client should go out, get the treatment that he or she needs, and the attorney should then work from that basis. So again, to recap, the statute of limitations of 3 years, you've probably heard, existing in Massachusetts, is only a guide. It doesn't provide for 100% of the cases. Venue is an important consideration that your lawyer should make, and medical treatment should be had at your direction, and medical evaluation can be undertaken at the recommendation of an attorney, but that's different from medical treatment. Thank you very much.